top 3 things a mature couple should be thinking about from an estate planning perspective from an estate planning attorney. Your will. You probably have thought about this. Everybody understands estate planning involves having a will or some alternative to a will. What is right for you depends on what state you live in. In Washington, we're a very friendly probate state, meaning it's very easy to do probates in Washington state. Same is true for Idaho. Other jurisdictions aren't so friendly, California, for example. Oftentimes you'll hear financial advisors and nationwide say, you must have a revocable living trust. Well, that's often bad advice in Washington. And the reason for that is that in Washington state, and if you are a mature couple, you may be more concerned about long-term care costs. Long-term care costs are the number one threat to a senior's financial security. And if you're married, you are probably concerned about making sure that if you pass first, your spouse is provided for and that they are not going to become impoverished due to long-term care costs. If you have a revocable living trust, you're not in a very good position in Washington state to protect assets for your surviving spouse. Why is that? In Washington, our rules require that you have a will and in it a special kind of trust if you want to protect money for your spouse against long-term care costs so that they can qualify for Medicaid benefits for the state to pay for their care. In other states, that's not the situation, but I'm talking about Washington state. So having a will with an asset protection supplemental needs trust is the number one way that we as estate planning and elder law attorneys can protect you and your spouse against long-term care costs. Let me just give you a simple example. Let's say that you and your spouse have $1 million and you die first. You have a trust. Your spouse inherits through that trust without the need of probate, so okay. But what happens with that $1 million that went to your surviving spouse? Let's say she has long-term care needs, memory care, dementia, any of those things. She's going to have to spend down her $1 million in countable assets, all of the money, all of it has to be spent before Medicaid will pay for her care. Instead, let's say you didn't have a revocable living trust because you met with an elder law attorney who understands Medicaid's rules and asset protection. You die first. Washington's a community property state, so of that $1 million, you own half. Your half will pay through your will, through a probate, into an asset protection trust for your surviving spouse. So after you're gone, there is this trust with $500,000 in it. Now your spouse may have $500,000 of her own money that she will need to spend before Medicaid will pay for her care, but she won't have to spend down that $500,000 that's in that trust. The state doesn't count that money. That is a pretty nice size nest egg that you have set aside for your surviving spouse, ensuring that she will never become impoverished and the state will pay for her care, even though she's got $500,000 in this trust. And then upon her death, what happens to that money, what's left in the trust? It will go where you said it should go, for example, to your kids or wherever you said you wanted it to go. So as a mature couple, it's really, really important that when you're thinking about what happens on your death, that you consult with an estate planning and elder law attorney to protect money for those you love. Now, all of that was about number one of the top 3 things mature couples need to think about. Number 2, living documents. And by living documents, I'm referring to your general durable power of attorney for finances, your healthcare power of attorney, and your healthcare directive, also known as a living will. You might not be thinking about those. Most people don't. They are not thinking about why would you need documents to protect you during your lifetime? Well, the reason for that is that we, as estate planning and elder law attorneys, want to protect you against the what ifs. What if this happens? What if that happens? It's not that unusual for someone as they mature to lose the ability to manage their own affairs. Typically that is from some sort of illness, a cognitive decline, some form of dementia, Alzheimer's for example, or it could be a stroke or any of the other physical ailments that could cause you to lose the ability to take care of your normal affairs like you used to. So if that happens to you, or if that happens to your spouse, absolutely critical that you have durable powers of attorney in place. The reason for that is that if you can't make your own decisions, somebody else has to. If you have durable powers of attorney in place, you may well have designated your spouse, a trusted person to make decisions for you, to manage your affairs. If you don't have those documents in place, what happens? The state steps in, and the state will call you, well, they won't actually use this term, but you're a ward of the state. You're subject to a guardianship, to a conservatorship. There will be a guardian appointed who has to report to the court your personal care plan, your financial plan. The state is the one, the court is making decisions about whether this property can be sold, and that it is a very intrusive, though necessary, proceeding for somebody who's lost capacity if they don't have durable powers of attorney. You can avoid all of that involvement by the court and by the state by simply having a power of attorney that appoints somebody to act on your behalf if you lose capacity. We're trying to protect your autonomy, your ability to live your life. One of the best ways to do that is to make sure that you've got a good, durable power of attorney in place where you've appointed somebody that you trust. So that's number 2. Number 3, what you should think about as a mature couple is what I'll call estate administration. What I'm referring to is what happens upon somebody's death. Who's going to step in and do the work of making sure that the terms of the will are carried out? Give some thought to who is the person that you know. Could be your spouse, it could be your children, it could be somebody else who is very organized, gets the work done, kind of has a business mindset, that they don't, get overwhelmed by tasks that they have to do. Estate administration is difficult for a number of reasons. Number 1, they've lost you. They are grieving. Probably they've never done this before and they don't know what to do. They will want to reach out to your attorney who drafted your documents because they will help guide them through this process of what is supposed to be done. I've mentioned before that Washington is a probate-friendly jurisdiction. It's pretty easy to do a probate in Washington, but that doesn't mean that it's commonsensical. There are very strict rules and times and deadlines and people that need notices and things that have to be done. The I's need to be dotted, the T's crossed, and that's not something that somebody who is a non-probate attorney is going to understand how to do. But if you select the right person and they select the right attorney, estate administration is going to be as simplified as it can be, not overwhelming. But it really is up to you to lay the groundwork, and by that I mean make sure you have a good will, make sure you went to a good estate planning and elder law attorney, give some thought to the right person to choose who will administer your estate, and then you've left them in the best position possible.